Good afternoon, dear viewers. Hope you all are well and safe. Welcome to our show, Law with Mahbub Toha. I believe you are already aware of that. We do this show on the latest updates on UK immigration laws, and we discuss some burning issues or topic. For this, we always invite a renowned professional from law professionals to discuss on those issues. Therefore, today we invited Mr. Asad Maksud. He is a barrister at Maxim Chambers. Mr. Maksud is a specialist in immigration, family, and public laws. Apart from those, he also represents the clients in the employment, mental health tribunals as a counsel. However, dear viewers, I'd like to introduce to you all our today's guest, Barrister Asad Maksud. Welcome to our show, Mr. Asad Maksud. How are you today?
Thank you, Mahbub. Very well, thank you.
As we discussed earlier, Asad, we decided to discuss on the issues like EU applications, appendix on EU applications, then the ways of long residence in the UK. So I want to, before going for those issues, I just want to know something like the latest updates on immigration laws for our viewers. We all aware that every day UK immigration laws are changing, and then so many issues are coming. So if you give us a brief description on the latest issues, like it can be from the home office, can be from the court or tribunals, so that our viewers can be benefited from there.
Sure, thank you. Thank you for that, Mahbub. Well, in terms of changes, of course, we all know that the most frequent change, in addition to the case law that comes through the courts, is the statement of changes in the immigration rules itself, because they periodically or often at a short notice update, and then there are it's usually much longer statements of changes with the memorandum that explain what those changes are, etc. And then it's something that immigration practitioners are probably very accustomed to and used to of. So we've got the latest of those statement of changes is dated 10th of September 2021, when there were a lot of minor and perhaps some big changes, but I wouldn't call any of those really major or groundbreaking as such. There are a lot of tidying up provisions. There are a lot of incorporations in them. There are a lot of fixing up of the slips, etc., here and there, rebranding, stuff like that. So what that does is effectively it gives us a number of pages of the changes, but they're not as scary as they seem at first blush. What the Secretary of State tells us with regards to these changes is that primarily the changes are being done to deliver the COVID-19 related concessions on the routes to be incorporated in the rules, and then changes relating to the evidence of identity and nationality requirements for people who come to the UK or seeking entry through Channel Tunnel. Then we have some provisions for Afghan locally employed staff. We have the launch of the international sportsperson route and associated changes required to other routes. And then we have the rebranding of Tier 5 temporary worker routes. We have increase in the list of eligible prizes under the global talent route. We have changes to the EU settlement scheme and expanding the youth mobility scheme to include Iceland and India. And then there are some series of minor changes that are explained in the memorandum to the statement of changes as well. When we look at these changes closely, in terms of first the concessions and the rules, so the concessions and the guidance that have been incorporated in the rules, we see with regards to, these are the main things because there are quite a few things, but I would just highlight the main bits here. So we have the Tier 1 entrepreneur related change, for example, what was done as a way of concession with regards to the Tier 1 entrepreneur migrant was that it was it was stated by way of concession that the businesses who have been negatively impacted by the pandemic, then they can apply, those applicants can apply for leave. They will have to show that there are two full-time jobs. However, they do not have to demonstrate that those jobs have existed for a minimum of 12 months period. So what the rules have been updated with regards to the settlement, that this second requirement must be met when you apply for settlement, in addition to the existing job creation requirement that applies to the settlement applications. And then, of course, there is the Appendix A of the rules where these changes are made in order to reflect this change. With regards to the EU settlement scheme, COVID-related concessions, it was said that in the guidance that if there is an absence related to COVID-19 because of which the continuous residence period is broken, then that will not impact the application under EU SS, and that has been incorporated in the rules. And it is also stated that from 6th of October, that concession will, 6th of October 2021, that concession will cease to exist. Then there are some COVID-related concessions incorporation under skilled worker route or tier 2 sportsperson route as well, in which various concessions that were previously in the guidance have been incorporated in the rules as well. We have then, as far as the evidence of nationality and identity requirement for persons coming to the UK aspect of the changes is concerned, we have the Secretary of State who had confirmed in October 2020 that there will be certain provisions in place with regards to that. So what the changes do is that they identify a set of individuals, which is called the citizens' rights cohort, that can benefit from keep using the identity cards. However, with regards to all the other people, it is stated that from October 2021, they will be using their passports as opposed to their identity cards as a way of entry when they arrive in the UK. Then there are some changes that relate to Afghan locally employed staff, and these changes, we're told, are being done to reflect some security changes in Afghanistan. It is said that they are enabling the current and former Afghan locally employed staff and their family members who are even now outside of the Afghanistan to relocate to the UK. Previously, the scheme that was ARAP, and the other scheme, they were only available to people who were within Afghanistan. So now it will be open to people who are outside of the Afghanistan as well.
Can I
And
just
then
pause you here for a second? Is there anything like this? Afghanistani people cannot apply for family reunification. Is there anything came out from the Home Office recently? I just wanted to be clarified.
What we are told here in these changes, what is being done is that they are also enabling locally employed staff who are approved for relocation to be granted indefinite leave to enter the UK, replacing the 5 years limited leave they are currently granted. And those who are already in the UK will now be able to apply for indefinite leave to remain before their limited leave expires if they choose to do so. As far as, of course, all the other working out of the settlement scheme are concerned, as far as I'm aware, they're still working on that. I'm not aware of the scheme that has been formulated fully yet, or the details that have been that have been released. I've not come across those changes yet, but perhaps we would see by way of guidance some information from the Secretary of State soon with regards to the Afghan citizens. But as far as the other categories are concerned, of course, they are in place. But there's a relevant point that I want to highlight here, that of course you and I and other practitioners would often come across clients who would have had difficulty in past in showing, for example, English language requirements or financial requirements under family categories. Under the circumstances as there are now, one would imagine that it should be pretty straightforward and simple for those people to ask for an exemption from those requirements and then come here under the immigration rules or outside, as the case may be. And then once they are here, of course, then they can get their extension within the rules. Or, of course, if they fall in one of these categories that there are, then they can, to start with, consider applying under these categories from Afghanistan or after they're here. As far as the other change with regards to the launch of a new international sportsperson route is concerned, it really is effectively rebranding of Tier 5 route, in which what is being done is that this one route of international sportsperson will replace Tier 2 and Tier 5 temporary worker routes for professional sporting workers. Apparently, it is being done to simplify the rules and to provide one streamlined route for people who come within these routes. Moving on to the global talent route, apparently changes to the criteria and evidential requirements required from the applicants, and for some clarity, these are the purposes, or this is the rationale for making changes to this. It is said that what is being done here is changes relating to the endorsement criteria and evidential requirements to reflect feedback and recommendations from the endorsing bodies for the route. So there are changes to endorsement criteria of arts and culture and evidential requirements for digital technology endorsements, and endorsement criteria changes for science, engineering, humanities, and medicine. And we have the endorsed funder fast track pathway amendment. These are really the things that have been done with regards to the global talent route. As far as global talent prestigious prizes route is concerned, we're told that the changes are done to expand the list of qualifying prizes to provide greater clarity. I guess it would be self-explanatory what changes have been done and what prizes and awards have been added to the list when it comes to these changes. Moving on to changes to the EU settlement scheme regarding joining family members and to improve clarity. So here we have the main changes with regards to this are that to allow a joining family member to apply under the scheme whilst in the UK as a visitor. So this is a change that has been done with regards to EUSS and EUSS family permit. And we're told that from 6th of October 2021, the temporary concession to this effect outside the appendix, where certain joining family members are concerned, will cease to operate. So it's been the visitors can apply to join under the appendix from within the UK, and that has been incorporated within the rules. And then there are some technical changes to reflect that the date of 30th of June 2021 has passed, and some technical changes to confirm the status of the exempt person, that they can apply to remain under EUSS, or they can apply once their exempt status has ceased. Moving on to the changes of youth mobility scheme, we have the rebranding of the Tier 5 temporary worker youth mobility scheme for it to be called now Youth Mobility Scheme. And then we have Iceland and India who have been added to that list. And then we have the students changes that are with some visitor and student changes actually. With regards to the visitor rules, there are some updates to incorporate the concession that was in the guidance previously, which allowed students to come to the UK to undertake the activity relating to a course that they are taking at a UK institution from overseas via distance learning. And these affect, of course, the students studying nursing overseas at the equivalent degree level to come to the UK to undertake electives at a UK higher education provider, as long as they are unpaid and they do not involve treatment of the patients. And then they say that this brings nursing students in line with medical, veterinary medicine, and science and dentistry students. And then we have the changes with regards to employees of overseas manufacturers or suppliers for clarity. And now they can come to the UK as a visitor in order to install, maintain, service, or advise on equipment, software, or hardware. There are some clarities with regards to that, nothing major as such. And then we have some changes to settlement protection rules to provide greater clarity. So we have these changes there with regards to people who've got the refugee status or their family members, etc. Now following a simplified version of the rules for making their applications. Changes to eligibility requirements for Hong Kong British national overseas route. Again, these are some sort of tidying up provisions where we have this route in which the concession outside of the rules to allow partner and child under 18, that concession is now being incorporated into the rules itself, the Appendix Hong Kong British National Overseas. And then there are provisions made within the rules for the child born in the UK of the parents who have such a status to allow that child to regularize his or her status. And then the correction and technical amendments to skilled worker routes. There are some there with regards to that. For example, that a correction is being made to make clear that the sponsor must be an A-rated sponsor to certify the financial requirement. And then we have some clarity with regards to the hourly rate of £10.10 that was introduced on 6th of April 2021, and that it applies to applications for settlement as well as for entry clearance and permission to stay, etc. And then we have other notable changes with regards to child dependents of a parent settled in the UK or British citizen or has the right of abode. They are simply done to address the gap in these provisions, and the dependent rules were in place prior to 1st of December 2020. And the provisions are being reinstated as they were before the rules changed on 22nd of October 2020. And again, it is with regards to the financial requirements as to who can provide the support, just bringing them in line or bridging the gaps, etc. And it is also said that by these changes, the Secretary of State is aligning all economic routes so that the relationship requirements appear under eligibility rules, not a split between validity requirements and eligibility routes. One can understand, eligibility provisions. One can understand why, of course, that would be done. Because what that would do is that the Secretary of State takes that stage approach in considering the application, first validity, and if you pass validity, it's fine. We go on to consider the substantive application. If it's invalid, then there will be no consideration to, for example, relationship requirements, because they will fall under eligibility requirements as opposed to validity requirements of the relevant or respective category. And then we have changes to eligibility requirements for settlement for representative of an overseas business. Again, it's a minor requirement where just a clarity is being made that there is no salary requirement with regards to the settlement rules. And that the applicant must show that they have met the requirements throughout the 5 years period when they were here, when they're applying for the settlement under overseas business representative category. Then we have the technical changes with regards to the general provision in Part 1 of the immigration rules. They're set out in the explanatory memorandum, and with regards to those, I guess these are the things that we understand from the rules already. It's mainly the technical changes, as the Secretary of State has put it. For example, one of those that in 34 GB, paragraph 34 GB of the rules, that when a person submits a new application which varies a current application, the date of application of the new application is the date of the is the date when the old application was made. Of course, these are the kind of things that we knew from the guidance already that were there, so they're sort of being clarified here. And then we have minor policy or technical changes to the rules with regards to Tier 2 Minister of Religion, that the applicants have to be aged 18 or above. I cannot imagine why anyone would be under 18 for that category anyway. But yeah, that there might have been a reason for that change to be made. And then we have renaming of the list of existing government authorized exchange schemes in line with the temporary work rebranding. And then this list was previously called Appendix N and is being renamed to align the name of the route it refers to. You probably would have seen from it the confirmation of the UK NARIC name change as well, from the references to from UK NARIC being to ECCTIS. I don't know if there is a short way of saying it, but
They are going to change the name, I think.
yes, to ECCTIS. I don't, as I said, that I don't know if there is a short way of calling it, but yes, UK NARIC was probably easier to say. Then we have some minor changes to Appendix Administrative Review and Administrative Review EU, and then some changes again to Tier 5 Temporary Worker International Agreement Worker route for contractual service suppliers and independent professionals. So swiftly moving on from perhaps the boring stuff, we have there's an interesting change actually that I noticed in these ones, that was with regards to the student and child student on keeping the funds when the application is pending. So that was an interesting one, because as the rules stood previously, it mattered that the funds were there for a certain number of days. So perhaps there was a need to clarify that in this memorandum, that it is 7.58 of the memo. Yes. So the Secretary of State is providing clarification to ensure that the applicants for the student and child student routes continue to have funds available to them after making their application. So there may be a good reason for having that change being put in place. And it says that the applicants must continue to hold the funds required throughout the duration of the application process, and to be able to demonstrate this if requested, or be able to demonstrate where funds have gone if said funds have been used to pay outstanding course fees or accommodation costs. So that is something that the students may be interested in. It doesn't seem such a big change. I would imagine that most people would have had the same financial standing throughout the application process, but just in case, if someone is minded to use that money while the application is pending, perhaps they should bear this change in mind. So these are really like some of the main changes that caught my eye when I read the explanatory memorandum attached to these changes. In terms of recent cases, a few of them perhaps I can mention that I found.
Okay, I think we can go there later on. But before that, as we mentioned in our poster, we will discuss on EU, Appendix EU applications. So we want to touch on this one first. Um, I just want to know from you a little bit about the Zambrano case, because we know at the end of the Brexit we have got this one from the court. So can you just tell me something? What is the situation now? Because so many people already made their application. So what was the situation of their application?
Do you mean the decision of the court that came out with regards to with regards to the principle that if somebody has a leave under immigration rules, that does not extinguish their right under EU rules or under Zambrano? Is that
Under Jamrano.
yes? Okay. Well, as far as I understand, the applications are pending now, but then at the same time, we have a Court of Appeal application by the Secretary of State also pending. So the Secretary of State is challenging that decision. So I would imagine that the applications will be put on hold, people who have applied, until the Court of Appeal has decided what is going to happen. Last time I was in the, I was told by a senior presenting officer a few weeks ago in a hearing that the permission has been granted and they've not got the date yet. I've not checked online yet whether a date has been issued by the Court of Appeal against that judgment of the High Court. But I would imagine that the applications will be put on hold. So the Secretary of State will want to see what happens with the challenge that they have in the Court of Appeal before it is decided what should happen with those applications. I mean, I would imagine that that most of these people are, of course, under 10-year routes, aren't they? Already have got 30 months visas, etc. So it is probably those people who made an application under these provisions because it's convenient. You get a leave for 5 years period, and you don't
In
have to
terms
pay
of
half the
fees.
fees. Yes, yes. So
I have
that is
few
where we are.
relevant questions relating with this one. One of my viewers questioned us, I have a pending application for limited leave to remain. Will I be able to make an EU settlement scheme application as a Zambrano carer?
Well, if it's pending under Appendix FM, the current application, yes.
Yeah.
Uh, and if they are if they are seeking to make a Zambrano application, of course, it comes down to this, that if there is a pending application under Appendix FM, is that, for example, as a parent or as a spouse? Either way, I can imagine scenarios and situations where you would also at the same time be able to show that if I have to leave, then of course my the British citizen would have to leave as a result of their carer leaving, etc. So if you meet the requirements of the Zambrano category in that regard, then the fact that you have not exhausted your Appendix FM application yet should not prevent you from continuing with the Zambrano application in the light of the High Court judgment. But then at the same time, the Secretary of State is still of the view that actually, no, you should first apply for Appendix FM or should apply for a family life application, etc., before, or you should be able to show why you cannot apply under that category before you go for a Zambrano application. That is really the point that the Secretary of State is taking further up in the Court of Appeal. So they can either apply for it and then be with all the other applicants who are waiting for the decision, or they can just wait and see what happens with that decision, and then it should be possible to make a late application as well, because of course it will be a reasonable excuse in any event that there was that decision pending, and then you saw the outcome of that decision, and then you made the application accordingly. It is possible under Appendix EU to make the late applications anyway, as long as there's a good reason.
All right. I have another question from another viewers. She has just written, I have no leave to remain. Will I be able to make you settlement scheme on this route, on under this principle?
Well, you don't have to have lawful stay in order to make an application under EU rights. So there's no reason why somebody should not be able to make an application. It doesn't matter whether they at the moment have status or they do not have status. Ultimately, it is down to, can you meet the requirements of the Zambrano category? And it's all about that. And of course, if at this stage you will also have to show why an application was not made sooner, what is the good reason why it could not previously be made? And of course, you would imagine that the person was here before end of December 2020.
Okay. Yeah. Then now you can continue with your course updates, like
Right, of
if
course.
there is any.
A few of them really. One related to, let's see, I actually came across this one only yesterday when I was preparing skeleton in a deprivation of citizenship appeal in the first year tribunal. So we have this case of Cicere, deprivation of citizenship appeals. I don't know if it's pronounced that way, by the way. Principles 2021, and this is a decision by the president and vice president of the upper tribunal issued on 8th of September 2021. What it does is it basically just sets out neatly the principles to be applied by the first year tribunal when determining an appeal of deprivation of British citizenship. So it sets out the staged approach and interaction of the consideration of the precedent fact, which is the fact of deception, fraud, forgery, etc. Its interaction with the human rights that are raised, and when it would be appropriate for the breach of that human rights and its proportionality to be considered, and that the tribunal must determine the reasonably foreseeable consequences of deprivation when considering that the human rights are breached as a result of that deprivation decision under Section 6 of the Human Rights Act 1998. And then we have, in the end, at number 6, that is the head note of the judgment, where it is said that if there will be no breach of Section 6 of the 1998 Act, then there is a set of pointers there that if there are these applicable, then the tribunal has the power to allow the appeal regardless of the fact that the decision does not amount to a breach of Section 6. So this is an important decision, perhaps more so, or perhaps only of the practitioner's interest as opposed to general public, because one would imagine that these deprivation of citizenship appeals would be prepared by the practitioners as opposed to the appellants themselves. In any event, for whoever is inclined to understand them as a layperson and apply them, then by all means they can benefit from it. Apart from that, last month in August, there is a decision of MY suicide risk after Paposhvili. That is 2021 at 232, decision of 23rd of August 2021. What it does is basically just sets out the approach to be followed in cases where the individual raises a significant reduction in his life expectancy arising from a completed act of suicide and or a serious, rapid, and irreversible decline in his state of mental health resulting in intense suffering falling short of suicide. So we have that approach to be followed after the decision of Paposhvili. We know that there was the decision of AM Zimbabwe in this context of Article 3, and that sets out the approach that should be followed in determining these cases. Apart from this, I guess not a surprise as such, but then there is a decision of the Secretary of State against Ali, and that is from Court of Appeal 1357 of 14th of September 2021, just a few days
You're
ago.
talking about Wakar Ali, Secretary of State and Wakar Ali.
Yes.
Okay.
It's a decision that basically defines in time, for the purposes of the rules, the disregard provision, basically. Effectively, in this case, the appellant was saying that and this is the Secretary of State's appeal, of course, because Judge Craig had allowed the claim in the upper tribunal, and the Secretary of State took it to the Court of Appeal. And it was argued by the Secretary of State that effectively, in other words, that you only get one 14 or 28 days window, you don't get two windows. The appellant, on the other hand, was saying that no, actually, the in time is not defined as narrowly as the Secretary of State says it is, and therefore you can have more than one 14 days or 28 days windows to make the application that would be considered in time. But of course, the Court of Appeal decided it for the Secretary of State, consistent with the regime in place for Section 3C. That means that you only get one 14 days or 28 days window. And of course, I was, and perhaps most practitioners were also always of the view that you only get one window.
Yeah.
You don't get more than one windows, and they were lucky to have that claim allowed in the upper tribunal before Judge Craig, but perhaps not so lucky, expectedly, in Court of Appeal. So we have these are the few decisions that have that recently come to mind when we look at the recent updates. But apart from that, of course, we know that every day we have some minor thing that comes our way in this field of immigration and asylum law. So there we are. Unless there's anything particular, of course, that is of interest, we have one more area. Well, actually, this last decision does touch upon our other topic, which relates to long residence, where I would imagine not many ambiguities are now left, and that most things must be clear by now in that area. But if there is any particular concern that you would like to highlight or explore, etc., then by all means shoot.
Yes. Okay. I want to move forward on continuous qualifying period of EU citizens. So many EU citizens came in UK and they applied for pre-settlement application, or now they are applying for settlement application. But the thing is, there is of course a qualifying period. How many days they can stay outside UK, or how many days they need to be inside UK. So nowadays these are coming. I believe you also received some instructions, this kind of instructions, like they have been refused from their settlement application. And so can you just clarify me how many days or how many months they can be outside of UK, or in total, or what will be the consequences? Like, there are so many European nationals who came in UK and then gone to Europe again, and then now came here to apply for settlement. So
From
what will be
memory
the
to
consequences?
from memory, to the best of my understanding, it's if your continuous residence in that context is broken if you've been absent from the UK for more than 6 months. So if you have been absent for more than 6 months, save good reason, one would imagine that you're going to have to complete your 5 years because it's been broken. So that really is all that there is. I mean, apart from that, one can look at the individual cases as to what was the reason, and if there may be cases and exceptional circumstances where that would be considered to not have broken the continuous residence. So 6 months it is really to keep in mind.
Yeah. Okay. So in that case, the COVID-19 concession will apply or not?
That does help, yeah. As we've seen that had provided some concession for a period, which has now been incorporated in the rules. So you would imagine that COVID really wouldn't affect people's continuous residence, even if they've been absent for more than 6 months. One would imagine that would, because of that concession, not affect their continuous residence.
I just want to add one thing here. If there is anyone, like he or she came here before 31st December 2020, but they did not apply for free settlement application. They went back to their home country in Europe, but now they are coming for doing application. So is there any chance, if any, then what types of grounds they can use?
So someone who had already moved here to live here before the end of December, and then they went back without applying for the status, and now they have to apply for the status. They were here before the end of December, weren't they? And they were here as long as they had moved here before the end of December. Even if they went back to their country and then they have come back now, or they want to come back now, I mean, they should. There's no reason why they shouldn't be able to apply under the Appendix EU scheme, the EU supplement scheme, because the requirement is that the person was here before the end of December. Not for a visit, obviously, holiday. I mean, you had moved basically effectively before that period here, and then there may have been a reason why you have to go. I mean, not many months have passed since after that period, so you would imagine that it is manageable. Very, it's in exceptional circumstances, one would imagine that that would not count. But if somebody had moved here before the end of December, there should be no problem.
Okay. In terms of criminal convictions, or the so many European nationals, they have criminal convictions here or in their back home. So what is the rules for them if they want to apply? Like non-EU nationals, we know the non-EU nationals, if they have any criminal convictions in UK, then they cannot apply, or that they are not given straight away the citizenship. So what rules or what laws will apply for them as well, who are European citizen?
So, in terms of the suitability requirements, there are, even when you look at the Appendix E, you've got the suitability grounds on which the application can be refused. Of course, that's not our topic for today, but let's look at the suitability requirements, what they say in terms of Appendix EU. So when we look at the Appendix EU suitability requirements, we have the application made under this appendix will be refused on the grounds of suitability where one or more of these criteria apply. For example, the applicant is subject to a deportation order or to a decision to make a deportation order, and then we have the applicant is subject to an exclusion order or exclusion decision. And then we also have the other mandatory refusal ground, which is that the application will be refused on the grounds of suitability where the presence of the person in the UK is not conducive to public good because of their conduct committed after the specified date. And then we have and of course we know that before the specified date we had different criteria in terms of deportation, etc. And then after the specified date we have slightly different criteria under this appendix. And then we have the discretionary refusal grounds, which is that the application may be refused on grounds of suitability where the following applies. For example, the applicant is subject to an islands deportation order or exclusion order of the islands. And then we have another discretionary refusal ground where the application may be refused, where at the date of decision the Secretary of State is satisfied that it is proportionate to refuse the application, where in relation to the application and whether or not, with the applicant's knowledge, false or misleading information, representation, or documents have been submitted, etc. The usual stuff, basically. And then we have, or it is proportionate to refuse the application where the applicant is subject to a removal decision under the EEA regulations on the grounds of their non-exercise or misuse of rights. And the date of application under this appendix is before 1st of July 2021, or then there is certain provisions mentioned there. So we've got like an extensive list of suitability requirements that need to be met. It is very hard to, I mean, we can, time permitting, set them or set all of them out fully, but I guess they are set out extensively in the appendix itself when it comes to now the suitability criteria that is applied. So that perhaps answers your question.
Yeah, so I have one little question. Like someone asked me, one of the viewers, she just said, "Do we need to disclose everything in the application?"
You only need to disclose in the application what the application form requires you to disclose. And by that question, I get the impression that there is something that the applicant does not want to disclose. However, there is no way around if the application form requires you to disclose that information. So if you are going to deal with the Secretary of State cleverly, perhaps it's best idea to get a legal professional to fill out the form for you so that they can understand and appreciate fully what is it that you do not want to disclose and what is it that the form requires the applicant to disclose, so that it is not possible for the Secretary of State to say that the material information was not disclosed, because you will have to disclose what the application form requires you to disclose.
Yes,
And that
the application forms or online applications are like plain. Do you have any criminal convictions? If yes, then what? So, what types of disclosure? Like, does she needs to write in details or just in brief? Like, then Home Office will investigate if they are interested.
it is like this, that you just have to answer the question, simple and plain. So usually it's pretty clear that what the form maker or what the Secretary of State has meant to ask when that question has been formulated in such a way. And of course, we all know that the forms have formulated the question in a sort of catch-all way. So it's hard to imagine that there will be conduct that will not be covered by those questions. And if it is not covered, then perhaps that is not so important anyway. You would imagine that if it was important enough, the question itself would have encompassed that. But yes, in isolation, answering that question perhaps is only possible by saying that if you just look at the questions carefully, and if you then believe that no, these questions do not require me to disclose this, and if you are advised so by somebody who is experienced in filling out those forms, then by all means, I mean, you don't have to disclose that if that helps.
All right. Okay. I have another question now. This question is. I'm an Indian national. I hold free settled status and have non-EU passport. I got free settled status on behalf of my brother and living here from last 2 years. Now I'm married and his spouse is French and she came to UK last month. Can she apply for free settled status on behalf of me or any other way to get her free settled status?
That's that is an interesting situation. We have to appreciate that this person will be an extended family member himself,
Yes, yeah.
and
Yeah.
that extended family member has his brother or as the EEA national, and we now have, by the way, in certain situations in Appendix FM, someone with a pre-settled status can stand as a sponsor. So perhaps they need to take advice on that, whether they fall within that provision. Because you see, there was a list of sponsors previously in Appendix FM that included the somebody with somebody who's British, and somebody who's settled, somebody who's got refugee status, etc. So we've got somebody with pre-settled status as well. So they need to look at that to be able to determine whether they fall within that category. But as far as Appendix EU is concerned, my preliminary thought would be that no, you wouldn't fall under that for bringing your wife here. So they will have to look at Appendix FM, family life with a partner application for that purpose.
Yeah, my understanding also like this. Okay, I got another one. Just this is the last one. He has just written, "I'm an asylum seeker, and my wife came here as a student, and now we have a baby, baby boy, and my wife uh, wants to do the graduate and road application now, and can she apply for our children as well as her dependent?"
Well, it it should be possible for the child. It is one child.
Yes.
Or children, yeah. It should be possible for the child to be the dependent of the partner. And from being asylum seeker, I mean, I can only assume that it's somebody who's got either an asylum claim pending or it's
I
been.
think so. Yeah, I think so.
Yes.
It's asylum pending. Yeah.
So in that case, the only person, if the only person with existing leave is the mother, then and the child was born here, it should be possible for the child to get the leave as a dependent of the mother. It should be possible. Yes.
All right, that was my last one. Okay, so if we want to move, like we have 10 minutes, we want to move on the long residence, like from which category or how people can be qualified for long residence application. Just
Yes.
if you want to add something in general, because this program is not for giving the specific answer, so we
Yes.
only discuss in generic circumstances, like, so if you give some ideas for our viewers,
Yes.
then
That's fine. Thank you. It's always very hard to know the background of your audience. So it is always safe to explain things, or at least start explaining them from the most simplistic point. And the most simplistic point in the long residence category is that you have to have lawful 10 years residence. Now, of course, for lawyers and for us, for practitioners, this is plainly stating the obvious, but that obvious is not so obvious to laymen and general public. That 10 years period has to be lawful period of 10 years, whether you have had leave or you have had section 3C leave continuing. Of course, we know what has happened in the cases of Junaid Ahmad and Masum Ahmad, and then after that, Hawk clarifying what the situation should be. So the applicants need to appreciate and understand that they need advice on, for example, if they are somebody whose last period of leave is doubtful, so to speak, then they need advice on whether or not that period can be considered a period under Section 3C leave, because they would be what was termed as open-ended overstay. They may or may not be actually open-ended overstayers, as it was termed in Hawk. And if they are open-ended overstayers, then of course they will need to get some kind of leave first, after which they may or may not be book-ended overstayers in a way which can receive a disregard from the rules for the purposes of 10 years category. Now, I did say at the start of this conversation that I would explain it in a simplistic way, but it is not always possible to be more simple when it comes to immigration rules. So you keep trying to find the simplest way of explaining the situation generally. So just to reiterate that the general situation would be that if you are someone who has been making an application after application in recent years, hoping that you are going to reach the mark of 10 years period, then you really need advice on whether or not you have actually reached that mark or that is a misunderstanding. So this is something, I guess, that is a sort of, that was and perhaps to some extent continues to be a burning issue in the context of long residence provisions. And of course, we know that this decision of Ali that we've just looked at, defining in time, that was also an attempt by applicants who were trying to argue something which would have benefited them in reaching that mark, by saying that, well, actually, there's not just one window, there are two windows, or even more, because the argument that they were raising would have meant that there would not necessarily be just two windows. There can be as many windows as you like. So that was also an attempt, an unsuccessful attempt to get that mark, to achieve that mark. So this is something that perhaps the applicant needs to look at, because we don't have any near miss. There were people who only had a month or two left, but their Section 3C leave expired, and they found themselves in an unfortunate situation that you've reached 9 years and 11 months, or you've reached 9 years and 10 months, and still this is where you are. When we know that previously if we had only gone back a year or two, it would have been perfectly possible for them to use the device that they have used to reach that mark, which is application after application or a variation after variation. I've seen many applications where there was a variation after variation and you reach the mark.
10 years, yeah.
But that changed because of Junaid Ahmad and Masum Ahmad, and Haq sealed that for us. So I guess that is what I wanted to add about the long residence applications. Still, because of the complexity of the area, some practitioners as well, so you can't blame just general public, even some practitioners still remain confused when it comes to it, whether or not somebody has completed their 10 years lawful residence period. So unless there's any particular question from your side on this area, I don't think there's anything particularly pressing that comes to mind to highlight here.
That's fine. I believe you mentioned and you touched so many areas. Though we cannot discuss anything particular here. So we always say we discuss in general. Thank you very much for giving us time from your valuable time.
You're welcome.
We believe we will get you in another time, and I believe our viewers also get benefit from your discussion. Thank you again and again.
Thank you for the invitation. Thank you, Toha.
Thank you.